I can't help stumbling over a lack of anybody being informed within 30 days of the permit not having happened on a project this large. I guess, therefore, if I accept that as making a 30-day exception in Luso, I don't see why it can't make them for the people that we have already granted standing. Is that a logical argument?
I understand your argument.
Okay. I guess,
Explain it a little better. I'm not.
okay.
not
What I'm
quite-
saying is that we granted a sense of neighborhood to people more than 300 feet.
We did.
Not only were the people 300 feet not notified, but obviously the people beyond 300 feet, who technically should not have been notified, were not notified. But they're impacted. We said that when we granted these people standing. In that, the Brackett case says that, and upheld, that if people were not notified, the 30-day window became an irrelevant one. Granting this impaction on the neighborhood allows us to say that the 30-day window is not the limiting factor now, and that there is law court
Precedence.
precedent for saying that. That was tier one of what Dan said we needed to say, have some justification for overturning Luso. The second justification was if there would be a miscarriage of justice in not hearing it, which I think is pretty clear. So I am comfortable with us granting the right for this appeal to be heard. That's me.
I second it.
You can't.
Okay.
Well, as I explained when we started, if we're not unanimous, it's defeated. Those are the rules, Robert's rules, those are the rules of any appeal board. I can't overturn that. We're not, if we had 5 of us here, and it were a 3-2 decision, it would be upheld. But when it's a 2-1 decision, it can't go forward, which means we can't hear the case.
I think it would be helpful for the board to actually, if there's a motion about the.
Okay.
The
I
timeliness
move,
issue.
I move that we do not regard 30 days as limiting in this case, having Brackett et al. Justification, and furthermore, that there would be a flagrant miscarriage of justice in the right to the people in this neighborhood being heard if we did not hear the case.
I second.
All in favor? Opposed? It's defeated. I'm very sorry. I don't know what recourse.
But I have another argument.
Okay, but wait a minute. After we do that, is there opportunity for,
If the board finds that the appeal is untimely, there isn't an opportunity to consider the appeal.
I disagree. I have a separate argument that has nothing to do with timeliness, and it doesn't matter how long it takes. It can always be collaterally attacked if it's unlawful.
Doesn't say that within the ordinance, James. If that's a court issue, a judicial, just like the good cause exception is a judicial issue. I think that there's every reason to believe that a court may find that a good cause exception applies here, in which case it comes back to this board and they get to deal with the substance of this thing. I think that my reading of the decisions and our ordinance is that that's the path that this has to take.
So just to be clear, Dan, you're not going to advise the board that the Justice Alexander's dissent and then approved by the court in Nestle means that you can attack a case at any time, regardless of time limits, if it was unlawful when it was originally decided.
You can't attack, the municipal board doesn't have authority to make that determination. The court certainly does.
Thank you.
Okay. I close the hearing. I don't close the meeting because I want to take this opportunity to thank you all for coming, to understand that you want to be a part of the process. I really sincerely hope this comes back to us and we have an opportunity to hear you. And I am very sorry that a legal technicality has superseded a community concern. And I really, really thank you so much for coming, and now I adjourn the meeting. We're off air.